Imagine dedicating your life to the United States Postal Service. You work your way up for nearly 2 decades until you finally become a postmaster. But what happens when your decisions are questioned, your motives are scrutinized, and your entire career is placed under investigation? This is the story of Loretta Short. Loretta was a Hispanic woman who worked for the United States Postal Service for over 20 years. Her retaliation claim against the U.S. Postal Service came to a very unexpected end. So, by the end of this video, you will understand how retaliation laws really work, including the 3 things you have to prove to win a retaliation claim, and why timing and documentation are critical if you ever need to protect yourself at work. This is a story every employee needs to hear because it shows how quickly your career can change and what you need to know to protect your rights. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. And on this channel, I do more than share legal opinions. I break down real cases to show how the law might apply to your workplace, whether you're an employee trying to protect your rights or an employer who's trying to do things the right way. Retaliation, it's one of the most insidious experiences an employee can go through. Of all the forms of workplace discrimination, retaliation cuts the deepest because it punishes people simply for doing the right thing, that is, standing up for their rights. Retaliation has deep and lasting impacts on employees as well. It affects them professionally, emotionally, and even physically. It lowers overall morale and trust at work when employees witness retaliation because they lose faith in leadership and the complaint process itself. And it doesn't just hurt the targeted employee. No, the person who is experiencing retaliation, that isn't the only one who's affected. Retaliation creates a culture of fear. It silences everyone. And not only that, it allows discrimination and unethical behavior to go on unchecked. That's why I wanted to cover this case today, so that I can share resources and tools to help you if you are ever confronted with retaliation at work. Okay, let's talk about it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult with a qualified attorney or HR professional for specific guidance tailored to your needs. And hey, don't forget to like and subscribe. Loretta Short began her career with United States Postal Service in 1998, and by 2015, she had become the postmaster of Hallbrook, Arizona. As postmaster, Loretta wasn't just an employee, she was a top leader of her branch. She oversaw operations, supervising staff, and representing the United States Postal Service in her community. It was a role she had worked nearly 2 decades to achieve. She thought she had made it, but with her promotion came conflict. Loretta believed her treatment changed because of her race and gender. On December 28, 2017, Loretta filed a complaint with the USPS Equal Employment Opportunity Counselor alleging discrimination. But instead of resolving her concerns, Loretta believed the complaint triggered a series of retaliatory actions that ultimately cost her the leadership role she had worked so hard to achieve. It all started on December 6, 2017. That's when Loretta informed her supervisor, Brandy Stoner, of her intent to take annual leave December 26th. 2017, Stoner asked about Loretta's coverage plan for the Hallbrook office, and Loretta shared her plans for coverage with Brandy Stoner. But Brandy said that Loretta's plans for coverage were inadequate, so she denied Loretta's leave request. But Loretta objected. She said she could approve her own leave as long as she executed on her responsibilities in the office and ensured coverage was there. She could go on vacation. On December 22, 2017, Brandy Stoner and the Human Resources Manager, Lorene Wiley, they held a conference call with Loretta, and they informed her that Brandy Stoner had the authority to disapprove vacation if it would adversely impact the United States Postal Service operations. At the end of that call, Brandy Stoner issued Loretta a direct order to report to work on December 26, 2017. Loretta acknowledged the order but added that she would report to work unless she was sick or as long as it was safe. Brandy Stoner reminded her to call the sick leave phone number and provide a medical note if she was sick that day. On December 23, 2017, Loretta drove to the home of Melanie Gray Mountain. Melanie Gray Mountain was an employee at the Hallbrook Post Office who worked under Loretta Short. She gave Melanie her keys to open the Hallbrook office on December 26th, and she instructed Melanie to complete a change of schedule form and to stand in for Loretta during her absence. And on December 26, 2017, Loretta called in sick. The next day, December 27th, 2017, Brandy Stoner placed Loretta on administrative leave with pay pending the investigation. Loretta was ordered not to access the Hallbrook office and was scheduled for a fact-finding interview on December 28th, 2017. However, that evening, Loretta contacted subordinate employees about the investigation, violating those directives that she received from Brandy Stoner. On December 28th, 2017, Loretta made initial contact with an EEO counselor challenging the denial of her leave requests, her placement on administrative leave, and the rejection of her sick leave documentation. Now, later in an affidavit, Loretta stated she first informed Brandy Stoner about her EEO complaint on January 13th, 2018. However, in a later statement, Loretta said she actually informed Brandy Stoner on December 28th, 2017. This inconsistency became critical in court because retaliation claims require proof that the employer knew about the complaint before an employer takes negative action against the employee. On December 28, 2017, after the first fact-finding interview, Brandy Stoner reassigned Loretta to the Flagstaff Post Office effective December 29, 2017. Loretta requested sick leave to take her children to doctor's appointments, but Brandy Stoner rejected that request as well. She told Loretta instead to use December 29th as a day off and begin work in Flagstaff on January 3rd, 2018. So what do you think, guys? How does this make sense? Loretta was denied leave for December 26 because her coverage plan was supposedly inadequate. But then she was placed on administrative leave starting December 27th, meaning she was out of the office anyway. Was Brandy Stoner really being honest about Loretta's coverage plan being inadequate? Or was there something else going on here? At Flagstaff, Loretta's job was to conduct street observations of mail carriers and clerks. She evaluated their performance and then documented her findings. Between January 3rd and March 22nd, 2018, Loretta conducted over 50 clerk and carrier observations. The acting postmaster at Flagstaff location was Rosemarie Grapp. Rosemarie was observing Loretta and noticed that Loretta was returning only a fraction of her observation forms. Some forms also lacked required details. USPS policy required that Loretta include the carrier's driver's license number and expiration date on every observation form. But that was not happening. And to make matters worse, when Rosemarie followed up with two carriers, and both said they had not been observed at all. So Rosemarie Grapp, she was concerned about Loretta's work product, so she placed a GPS scanner on Loretta's USPS vehicle, but she didn't tell Loretta that she had done it. That very day, Loretta turned in a form stating she had observed a carrier named Daiwan Kawantawa. But GPS data suggested that Loretta was at a coffee shop and driving around, not following the carrier. Diane Kawantawa stated that she had not been observed at all. Rosemarie Grapp then confronted Loretta, and Loretta blamed technical delays with the tracking app. But Grapp, however, did not find evidence of a problem with the GPS tracker system she placed on Loretta's car. On April 12, 2018, Brandy Stoner conducted a third fact-finding interview, this time focusing on Loretta's street carrier observations. On April 13, 2018, Brandy Stoner placed Loretta back on administrative leave pending an investigation. On June 25, 2018, Stoner issued Loretta a notice of proposed removal, charging Loretta with failure to meet duties and responsibilities of her position and unacceptable conduct. On January 24, 2019, Troy Weber, the deciding official, he issued his decision, and he downgraded Loretta to a clerk position in Crown Point, New Mexico. This was effective as of February 2, 2019. The reasons given by Weber in support of Loretta's demotion were her failure to report to work on December 26, 2017, despite a direct order, her leaving a rejected coverage plan in place at that office, and giving keys to a subordinate beforehand. Also, she falsified carrier observation reports, and Weber also cited multiple additional professional failures. He said that these actions were egregious in nature and that her trust as a postmaster had been irrevocably eroded. And while he decided against full termination, he concluded she could only be rehabilitated in a non-supervisory role. Union representatives described Loretta's reassignment as punitive and vicious. Billy Garrett, a retired postmaster and union advocate, he called her case the oddest he had ever seen, and he went on to say that he believed they were after Loretta any way they could get her. On October 15, 2020, Loretta filed suit against the United States Postal Service, alleging retaliation under Title VII. On October 7, 2021, USPS responded to Loretta's claims, arguing that many of the adverse actions Loretta complained about happened before her supervisor knew about her complaint. They also said that they had legitimate reasons for disciplining Loretta based on her own misconduct, and that the decision makers involved weren't even aware of the claim she filed with the EEO counselor. Ultimately, the court agreed with USPS, ruling that Loretta failed to prove her retaliation claim. And here's what the court said. Although Loretta engaged in protected activity and suffered adverse actions, she failed to prove that the negative actions taken against her were caused by her claim of discrimination. The court also said that many of the adverse actions Loretta experienced happened before her supervisor knew about the complaint, and that actions taken after her supervisor knew, well, they lack sufficient evidence of retaliation. Loretta's story shows how timing is everything in retaliation claims. Employers have to know about the protected complaint before any adverse actions occur. Credibility and consistency, guys, they matter. Conflicting statements about key dates can destroy a case. Not every unfair or punitive action is legally retaliation, even when it feels targeted. If you want to know more about timing and its importance in retaliation claims, check out my video called Covert Workplace Retaliation Explained. I'll put a link for this video in the description, so check it out. As Loretta's case was being adjudicated in 2021, retaliation claims, they were at an all-time high. That year alone, retaliation accounted for about half of all EEOC charge filings nationwide. Retaliation can happen to any employee in every industry, whether you work for a federal agency like Loretta Short or in a private sector job. As Loretta's story shows, proving retaliation is not always simple. Even when it feels obvious, courts require clear evidence that the employer knew about the complaint before taking adverse actions. If you made it this far in the video, this is likely an important topic for you, so I wanted to take a moment to talk specifically about the way Loretta was treated in this situation in hopes that it might help you if this is something you're confronted with. First, on December 23rd, Loretta took the keys to Melanie Gray Mountain, who worked under her at Hallbrook Post Office, and told her to put in a change of schedule so that she, meaning Melanie, could show up and act in Loretta's place on December 26th. To me, that clearly shows Loretta had no intention of showing up to work that day, and let's be clear, this was the day after Christmas. Many people take it off to recover from the holidays, shop post-Christmas sales, spend time with family, people who are still visiting, or even prepare for New Year's. It's a significant holiday for many employees. What struck me is that the reason given for denying Loretta's leave, that the office wouldn't have adequate coverage, that didn't seem reasonable. At least I couldn't find any explanation in the case documents about why her being off that day would have been a problem. In situations like this, it's so easy to let your emotions take over. And I get it. When you feel like you're being targeted or treated unfairly, your first response is to fight back or stand your ground. But the way you fight back is so important. In this case, Loretta could have filed a complaint and stated in the complaint that she was being discriminated against because there was no rational explanation for the denial of her request for the day off after Christmas. Then the ball is in UPS's court to explain why Loretta can't take the day off and prove that it's not an issue of discrimination, but a legitimate business reason. And if they didn't have a rational business reason, which again, I couldn't find one in the case, but if they didn't have one, that denial becomes another brick in the house that Loretta is building to prove discrimination. Discrimination can be over time. The point is to document what is happening, the frequency in which it is happening, so that you can show and demonstrate to the court or to another agency that this is something that you are experiencing. It's not a one-time occurrence. But instead, Loretta responded by acting out, which is exactly what happens in circumstances like this when people are pushed and prodded to the breaking point. But here's the thing, when you let your emotions lead your actions, you can end up hurting your own case. If there really is retaliation happening, you need to let the facts speak for themselves without giving your employer any reason to question your behavior. Because the moment you act out of line or with what the law calls unclean hands, your credibility takes a hit. And then, instead of seeing the retaliation, people start to see you as the problem. In Loretta's case, if she had made just one misstep, it might have been forgiven, but her errors kept piling up. And with each mistake, her credibility weakened, making it harder for anyone, including the court, to see her as the victim. Let me give you a bit of insight about bad bosses. You know exactly what they're doing. They'll push you, prod you, and provoke you until you react. Because the moment you act out, the focus shifts away from their misconduct and what they're doing and lands squarely on you. That's how they protect themselves, by making you look like the problem. Loretta's short story shows us that retaliation can happen to anyone in any job, and it's more common than most people realize. But it also reminds us that proving retaliation isn't easy. Courts require clear evidence, not just that you were treated unfairly, but that your employer knew about your complaint before they took action against you, and that their actions were serious enough to count as retaliation under the law. By understanding Loretta's case, you know that timing, documentation, and credibility are everything. Protect yourself by keeping detailed records and knowing your rights, because while the law can protect you, you also need to build a strong case that shows exactly what happened, when it happened, and exactly why it mattered. If you found this story helpful, share your thoughts in the comments below, and don't forget to subscribe for more real workplace stories to help you protect your career and your rights.